application in the matter of Mohammed Farouk Hussain Baparee and Secretary of State for the Home Department.
Yes.
Thank you, Your Lordships. I am here on behalf of the appellant, and from Mr. Yarrow is here for the respondent in this case.
Yes.
I'd like to apologise first of all for the extra work that's been caused by the court and to your court staff in this appeal. I'm very sorry about the late flurry of paperwork, and I'm sorry that the extra work was caused to, as says, the court and to the staff.
I wouldn't worry about that. We're here to do a job, so we'll do what's required. But what we do need help from both of you, Tom, is that we need to make sure at any given stage of the hearing that each of us is looking at the right document at the same time.
Yes.
Now that may mean that we have to go a bit slower than you might otherwise do. So can you just keep an eye on us, make sure that we're actually following anything that you want us to look at. And I, subject to any submissions that may be made, I take the view that we should look at anything that the parties think it's important for us to look at without deciding at this stage whether it's admissible or not. And we will, in the course of our judgments in due course, say whether it's admissible or not if there's still an issue about it.
I'm grateful. I can say this, that thanks to your clerks, I think we all have the same core bundle now. My learned friend and I received the bundle that the court's working from.
Is that the electronic one?
Yes.
Okay.
This morning.
Right, I have that on the second screen. So,
I'm grateful.
certainly speaking for myself, I can look at that. And may I just check that my lord has that?
Yes, I've got that. I've also got the bundles which were lodged on the 2nd of October, the core bundle and the supplemental bundle.
Yes.
The core bundle was 108 pages, I think. But
yeah, I have that too. But if you're content, both of you, to work to the electronic bundle, then
yes,
we'll work to that pagination as well.
I'm grateful.
I'm aware that in the last few days there's been some loose documents filed, which I have in hard copy, and I believe my lord has as well. If something isn't on the screen,
yes,
and we need to look at a hard copy, just be patient. Just tell us what you're looking at, and we'll find it. All right?
Certainly. Yes. I should perhaps begin, my lord, just by framing the way I'm going to put the appeal.
Please do.
So my principal argument is going to be that, notwithstanding the flurry of extra material post-decision in this case, the real heart of this appeal and the way to get to the right answer in my submission is to look at what the judges below had before them and what they said about it. And my submission is that this is actually a much simpler case than it's ended up, and that actually if one looks at the reasons they gave for essentially disbelieving the appellant's account of having attempted to lodge his claim earlier, and those reasons for the arguments I put forward cannot stand. There is really only one material fact that's an issue, and that's the question of whether or not the claim was posted on the 26th of March 2023. I needn't take my lords to the underlying viability of the judicial review because the court below accepted that all other things being equal, it was an arguable claim. It's obviously also a case and a claim which has very stark consequences for the appellant and his family. So there was a lot at stake for him in the hearing below. I'm going to take you first of all, if I may, my lords, to the transcript of the hearing before the judges below. Then I'll take you to their judgment. I'll take you briefly to, I think, 3 authorities close just with some arguments. Pausing there, if you're with me on my principal argument that there is something wrong with the judgment below, I think then my learned friend's case will be that the post-decision evidence comes into play in seeking to persuade you that essentially it's an immaterial error, and that the evidence surrounding, or where we've ended up with the evidence, means that it essentially would be a futile exercise to remit it, because the evidence is now capable of one answer and one answer alone. And I would push back against that categorisation of the evidence. It may be most convenient to do so in a reply.
Should we see how we get on? And can I just ask you, this was listed for half a day.
Yes.
I don't know if you've discussed with your colleague dividing up time. I don't intend to be prescriptive, but I will be if I need to be.
Yes.
Because I want to be fair to both sides.
I don't want to make myself a hostage to fortune, but I would have thought, my lord, I will be finished by 11:15.
All right. Well, let's see how we get on. I won't hold you to that strictly, but that's a helpful guide figure anyway.
I'm going to attempt to make things as simple and straightforward as possible.
Good.
Given the narrowness actually of the factual issue.
All right.
So the transcript begins on the electronic bundle at page 333 of the PDF. The electronic PDF numbering and the internal pagination is not in sync, I'm afraid.
Yes. Are you able to give me? Oh yes, it is. Yes, 333. Is it 311?
Yes.
Yeah, I've got it. Yeah.
I'm
Well,
grateful.
I typed in 333, and that's the page that came up, which is a good start.
So that is a good start. Yes. Better than I hoped. So the relevant part of this transcript reader brings at 349.
Internal pagination, that would be
That begins at 327.
thank you. OI 16. Okay, thank you.
So the build up to this particular section is that Mr. Baparee, the appellant, is called to give evidence on the question of timeliness, and he is asked at the bottom of.
I'm sorry. No, the system's gone wrong. I'm afraid, because I tried to type in 349, which has taken me much further into the bundle than you want me to be. So, do you want me to be where it says in hard copy 327?
Yes.
Let me just find that. Right, I have it. Thank you.
So there is a series of questions by the appellant's own barrister adopting his witness statement, and then Judge Perkins takes over the questioning. At the bottom of page 327, internal pagination, the witness is asked, "Can you remember what day you posted it?" And he gives the answer at the bottom of the page. It was a weekend, Saturday or Sunday. And then skipping forward to the bottom of 328.
Bottom of 328.
Yes.
Yeah, got it.
Judge Perkins then, after some other questions, picks up the question by saying, "One thing that's really troubling us, Mr. Baparee, is that just remind us of the date on there, please." What is the date on there? 26th of March. 26th of March, yes, we've looked it up, and we think 26th of March is a Sunday. Could that be right? The answer comes, yes, weekend, it was weekend, my lord, Saturday or Sunday. Judge Perkins says, "We are not aware that post offices must be aware that post offices are opening on Sundays." Yes, post offices are open on Sunday, comes the reply from Mr. Baparee. You'll see just under the bold where it says pause, there's no cross-examination on the point.
Yeah.
and then my learned friend, about halfway down page 329, invites the tribunal to take formal judicial notice of the fact that post offices are not open on a Sunday. So that's the extent to which the issue that's now taken some centre stage in this appeal was ventilated below. I'll ask you then to go to the judgment itself. I think it hopefully is at.
Just whilst we're on that page,
Yeah.
329, page 18 of the transcript, line 28, yes, I've been Googling for that. Is that, it said by the other side, that's a reference to the screenshots.
Yes, I mean, we have asked Mr. Georget to comment.
Sorry, Mr.
Georget, the barrister,
Yes, yes,
below,
yes, of course.
to comment on what was going on in the course of the hearing. We haven't had anything in writing from him. I think that it's agreed generally that the screenshot made an appearance. So the screenshot that made an appearance in the confines of the court, whether or not it was formally shown to the judges in any way.
I thought that wasn't accepted.
My lord, I was at the hearing, and it was. I saw a screenshot, I believe, in the corridors during the adjournment prior to judgment.
Yes, but
So that's the part that.
Your witness, Ms. Ferris, has said that it wasn't. It's claimed that it was shown to the Upper Tribunal, but it wasn't.
Yes, so that is an
That's your
issue, my lord.
position.
Yes, my lord.
I'm sorry to interrupt. That's the only reason why
Yes,
I asked about this passage.
I think so. There's a distinction, I think, between whether it was, to sort of paraphrase, floating around the tribunal room in the corridor, or whether it was actually formally shown.
Whether it was before them.
Yes, yes.
Okay, thanks. Sorry to interrupt.
No, not at all. So, my lord, I was going to then take you to the judgment itself.
Yeah.
By the way, I'm sorry to interrupt again, but whilst we're on the bottom of page 329, it says judgment transcribed separately. Now, I know we've got the written reasons which form part of the order. My recollection of sitting in UTIAC is that there's a statutory obligation to give reasons, which is why it's in the order. But the practice has been to give summary reasons in the order, which don't necessarily exhaust what was said extempore.
Yes, I think so. I think what I've said in my supplementary skeleton is the practice is that there is the appellant is given, sorry, the applicant is told why they won or lost at the time, and then there is a written order which is sent out. That can sometimes have more reasons, can sometimes have less, it can sometimes have exactly the
Well,
same.
speaking only for myself, when I used to do this, it would have less, because you might have several cases in the list in a day, and the main reasons. It says it's been transcribed separately. Is it available?
I've not seen it.
No. Sorry.
So when you say you're going to take us to the judgment, you mean the written reasons?
Yes.
Which page is that in the electronic bundle?
So electronically it's PDF 299 or internally 276.
299.
Yeah.
Yep, that worked. 10th of October 2024 is the seal date. Is that right? Got the right document?
Yes, that's
Okay.
correct. And
Right.
it's dated the 9th of October, which is actually the date of the
I see.
hearing.
Right. Okay. Right. So these are their written reasons. Right. So what do you want us to read?
So it's really paragraph 6 that contains, well, paragraph 6 and 7 that contain the main reasons for the tribunal disbelieving the appellant. I'll just perhaps just invite you to read paragraph 6 and 7.
Right.
So there may be a difference between the parties as to the status of the final 72, paragraph 6. The certificate of posting is dated 26th of March 2023, which we believe to be a Sunday. In our experience, post offices are not open on a Sunday. I'm going to say one of two things. Either that is an example of judicial notice, or if you're against me on that, that it's certainly an example of a mistake of fact infecting a decision. The reason I say it's an example of judicial notice is because it's a decision by the judge on a fact in issue, essentially, where there was no direct evidence on that fact in issue. And the judges have drawn from their own knowledge or experience, as they put it, to essentially what they must be doing is extrapolating from their view of the general to the particular in this case. So from the appellant's point of view, his positive case is, I posted a claim form to the Upper Tribunal on a Sunday. The judge says, in terms, post offices aren't open on a Sunday. So the appellant, in those circumstances, is going to find it very difficult to succeed before a judge, because obviously if the general is that post offices aren't open, his individual post offices at best are highly unlikely to be open. The difficulty with that is it's not true. That post offices are, as a matter of fact, open on Sunday. Many of them are. And really the nub of this case is that it was either an error of law to take judicial notice of a fact which was not so notorious as to fall into that category, or to put it more prosaically, simply an error of fact to take into account a general experience that wasn't true.
If it's the second, are you there relying upon E against the Home Office?
Yes, that's why I put that in.
Suppose we were to accept that submission, what would follow on your submission? Do we then decide that the claim was filed within time, or do we remit the matter to the Upper Tribunal to consider the matter again in accordance with the judgment of this court?
Well, I think the answer to that question, without wanting to be obtuse, my lord, is that it depends how far we get with, for example, the new evidence.
Well, that's why I asked you to pause where we are now.
Yes.
Right? Forget about new evidence, you haven't heard anything from the respondent yet. Just on your submission, you've advanced a case. It's very clear and succinct, which in my book is a virtue, not a vice. Suppose we accept that submission. What then follows?
Well,
do you say?
I think it follows. So so I was just thinking back logically. The Upper Tribunal gave a couple of other reasons.
Yes.
Disbelieving his evidence.
Yes.
I'll take you to those and seek to persuade you that they were either infected by the overall view of credibility, or couldn't sustain an adverse credibility finding on their own. So I think the first question would be whether or not, if you're with me, that the entire decision is unsustainable. And then the question becomes, well, you have the appellant's evidence that he posted, if we're sticking with the evidence that was before the tribunal,
Yes.
is essentially unchallenged evidence during the
Yes.
course of the hearing that he posted.
I understand that submission.
So perhaps if it's convenient, I'll just deal with the other reasons, just to try and persuade the court that they couldn't have been enough on their own to support essentially a finding of dishonesty. And secondly, that even if they could be categorised like that, they'd nevertheless be infected by the overall finding that he couldn't have done what he said he did.
Yes.
So there was some discussion in the course of the hearing in the transcript about his reasons for being in West London. He gave evidence that he liked the structures. He spent his weekend in West London because he liked the buildings and so forth. Paragraph 6, the tribunal recite that without comment, after saying we find the evidence concerning the attempt to serve the papers on the tribunal to be unsatisfactory. The applicant lives in Ilford. The applicant says he spends time in West London because he likes the structures. There's nothing there criticising that as a sentence, but it's part of the recital. The next part is this part about the certificate of posting being on a Sunday.
Yeah.
There's the finding at 7 that the tribunal found it remarkable that he kept the proof of posting in circumstances where he didn't send it by recorded delivery. I would simply say, as I said in the grounds, that is not a thing that is, in my submission, so remarkable that it could found a finding of dishonesty. There's a slight non sequitur in my submission in that reasoning in the event. Proof of postage on its face is kept as proof of postage. But
Are they saying that they don't believe the certificate is genuine?
that must be the inference.
Yeah. You say that it's not unknown for people to forget to post something by recorded delivery, or perhaps decide not to because it could cost some money, for example. So what I think you would say, what's so strange about someone who has kept a certificate?
Well, I mean, I'd say two things. One, it's difficult to see why it's remarkable, and secondly, it's the whole point of the certificate of proof of posting is that it's kept in case you have to prove that you posted it. So, I mean, there's nothing remarkable about keeping that amongst your papers, because otherwise there'd be no point in taking it. It's not a disposable item, for example. It's kept for the purpose with which it's given, to show that on a particular day something was posted when you said it was. This is also obviously somebody who, at this point, is acting effectively as a litigant in person. And he's obviously somebody who his background is from abroad. All of those things need to be taken into account when deciding whether or not it's so remarkable that he didn't use special delivery and kept his proof of postage that somehow counts against him.
I mean, we had a few years ago we were deciding a case called Balajigari. Very different context, I know, but we had to think very carefully in that about the distinction between negligence and dishonesty. And in many parts of the legal system, the courts come across people who are perhaps careless. It doesn't necessarily follow that they're being dishonest.
Yes, precisely so. And also, it's important not to judge somebody who is a layperson by the standards that lawyers would take to an audit trail, for example, ensuring that every I is dotted and every T is crossed, because lay people don't have that degree of structure generally in their everyday dealing.
Well, that may be right, but this is a context in which something very important in your life is being posted.
And you've obtained the proof of postage.
Yeah, I understand that. Yeah.
I mean, you know, in hindsight, I dare say he wishes he sent it recorded delivery, but it's a leap, and it's a leap with which the tribunal are not entitled to take, in my submission, to say that is such a remarkable feature of the case that it's one of the pillars in which they hold up an adverse credibility finding.
In paragraph 7, is the tribunal necessarily suggesting dishonesty? Because in the second sentence, they begin with the words, "that may be right."
Well,
it's ambiguous, isn't it?
I think that the way I put it, my lord, is that these are the reasons that are building up to paragraph 10. So paragraph 10 is a finding that, notwithstanding the appellant's very clear evidence.
Yes, but that's based in part on paragraph 8.
Yes.
We're not satisfied we've been given a full explanation.
Well, the structure of the judgment I would seek to show you is that this part begins at paragraph 6. The starting sentences we find the evidence concerning the attempt to serve papers on the tribunal to be very unsatisfactory.
Well, I was going to ask you about that because that's the first sentence of 6, and then the second sentence is we ask to hear all evidence from the applicant. So perhaps the first sentence is referring to the material which was before them on paper before they heard anything.
Well, possibly, but they, having recited paragraph 7, 8, and 9, they end up with essentially a rejection, not satisfied, but it was then sent. So the appellant's case very squarely was, I went to a post office on the 26th of March 2023. Here's my proof of posting, and I posted it to the Upper Tribunal. That's his evidence. Wasn't cross-examined on it during the hearing, and the tribunal's conclusion is, well, we're not satisfied that's true. In the same way that a judge makes a finding in any court, they've listened to the witness and decided that he's not made out his case.
And you draw attention to the fact that, according to the transcript, the reason why there was no cross-examination of the applicant appears to be that counsel was content to fasten his case to the submission that post offices, you can take judicial notice of the fact that post offices don't open on a Sunday.
Yes.
That then finds its way into the court's reason, the tribunal's reasoning in the final sentence of paragraph 6.
Yes.
So you submit that putting all those bits together, it's tolerably clear what their reasoning must have been, that was at least a central part of the reasoning, if not the only reason.
Yes. And it's clearly, I mean, I'll go to the authority of the E&R in due course, but that makes it clear, if we're talking about a mistake of fact, for example, that that mistake has to simply be material. Yes. It has to be decisive.
No point.
But it's clear that it's material because it finds its way into.
Well, that's why, and I'm sorry to press you on this, but I'm not sure I still fully understand what your answer is to my question of what we then do. If I'm not saying you're right, we haven't heard the other side yet, but if you're right in what you've said so far, what follows? Do we remit it?
So I suppose in descending order of desirability from the appellant's case, if possible, given the evidence essentially at that stage is the evidence before you,
Yes.
I would say is unchallenged as to what he did. I'd ask you to consider the matter yourselves, extend time, and grant permission because the decision about the viability of the underlying claim has already been.
Do we need to extend time? Maybe we do, because the rules require it to be received, and
I think there would be
your case is that it was posted, but it doesn't necessarily follow that it was received.
there'd be a technical argument about whether it was filed.
Well,
So I
the
think
rules use the word received. We'll be looking at the
Yes.
Upper Tribunal rules at paragraph 28, I think.
Yes.
yes.
Anyway, you're not saying that the extension of time is not required, but you do invite this court to grant an extension of time.
Yes, I mean, I think the way that the case has been put, and also I think the way that Lord Justice Stuart Smith saw the case is that if it was established as a matter of fact that the claimant, the appellant, sent the claim form as he describes within the 3-month period, then it would be very difficult to see an argument as to why he should be shot off from relief now, even if the Upper Tribunal didn't receive it, particularly where the underlying claim has been considered to be argued.
That's your primary submission.
Yes.
But if that's not accepted, what do we do?
Then it ought to be remitted to the Upper Tribunal.
For what question to be decided?
Timeliness. Or I use timeliness as a bit of a shorthand in terms of the central factual question of whether or not he posted it when he said he did.
Would it effectively they be redetermining the application for an extension of time?
It would be, yes, it would be setting aside the judgment as it stands, and the question of admittance would be at large.
Yes. Oh, sorry, yes.
Yeah.
Admittance. Time.
Okay. And we were to accept that submission, should it be remitted to the same constitution or to a different constitution, or doesn't it matter?
I think it should be a different constitution.
Because
Well, because this constitution has already made a finding that, in their view, there's an inherent credibility issue generally with the case. And in terms of the appearance of fairness with this appellant, in my submission, it should be a new tribunal.
yes, and this isn't like a 3 months commercial action. The judge may be immersed in a sea of evidence. This is a fairly short matter, which you would say any constitution can deal with quickly.
Yes, and it's familiar territory for the Upper Tribunal, in my submission.
Right, I understand that. Is there anything else you want to say on that particular topic?
I think just before I leave the judgment itself,
Yes.
I just want to pick up on something that emerged just between exchange from the bar and the bench there.
Mm.
Just in terms of the status of the Sunday opening generally, because it's right to say that it was considered clearly by the respondent to be a killer point, because obviously if post offices aren't open on a Sunday, there's no point in descending into the details. It simply ends the forensic question. And you'll see that it is one of the quite short reasons that's given by the tribunal. So it was clearly material. And in the transcript, you may recall, my lord, that it was described as something that was really troubling the tribunal, the fact that it was a Sunday that it was said to have been posted on. So this is all in the context of there being no direct evidence before the tribunal as to the opening pattern of this individual post office. This is all extrapolating from a general impression as to post offices generally. So it's clearly highly material in my submission to the decision.
Right.
I think that's all I need to take you to on the transcript and the judgment, by the way. I'll take you briefly to some of the learning.
That I think we do have in hard copy.
Yes, I think there's also an electronic bundle as well.
Right.
But if there's any difference between the hard copy and the electronic copy, that is entirely down to me.
No, don't worry. I have the hard copy bundle in front of me, as I think my lord does. So let's see if we can make progress using that.
Yes. So one correction, if I may, just in terms of my supplementary skeleton argument, I have ascribed a paragraph in my supplementary skeleton to the Commonwealth Shipping Representatives case at tab 1,
Yeah.
which ought to have been ascribed to the Scott and Attorney General of Bahamas case at tab 6, but I'll show you that as we get to it. So those two cases that I mentioned, Commonwealth Shipping and Scott of the Bahamas, are two examples of the courts considering judicial notice. The best summary is at tab 6 in the Scott case. And at page 110 of the internal pagination.
Yeah.
Hopefully you have paragraph 40.
We do.
This is Privy Council case,
Yeah.
and it's a discussion about the extent to which the courts can take judicial notice of facts that have been proved elsewhere in the evidence. Can I just invite you to read the two short paragraphs of paragraph 40 and 41?
Yeah. Yes.
So you'll see that the paragraph 40, there's an extract from Cross and Tapper.
Mm.
The judicial notice refers to facts which a judge can be called upon to receive an act, either from his general knowledge of them or from inquiries. So this was a case not about inquiries. So there was no inquiry of extraneous sources in the tribunal decision. This was taken from their own general knowledge and experience. And paragraph 41, perhaps unsurprisingly, is the party who says that a judge should take judicial notice of a fact. That has the burden of convincing a judge that that ought to be the case. And again, it's in two categories. Firstly, the matter is so notorious as not to be the subject of dispute. Or secondly, capable of immediate demonstration by resort to accessible sources. And again, in this case, it's the former rather than the latter. And I don't think it's in dispute that post offices not being open on a Sunday is not a matter which is so notorious as to not be subject to dispute amongst reasonable men or women. That's the respondent accepts that. This is simply not the case. So if you're with me on my categorisation of the tribunal decision as taking judicial notice, they were not in terms of binding authority, they were not permitted to do so. If you're against me, I think my learned friend's going to seek to persuade you that this was not an example of judicial notice. At the very least, I would submit this was a mistake of fact amounting to an error of law. And for those purposes, I ask my Lord just to turn up tab 4, which is the case of E&R, and it's paragraph 66. Which hopefully you have at your page 67.
Yes, thank you.
So the context of this particular paragraph and E&R as a whole was in the context of statutory appeal. But my submission is that one can potentially read across this into the present circumstances because the statement of principle applies. So at the beginning, perhaps I could just invite my lords to read paragraph 66.
Yes.
So you'll see, my lords, at the end of the second half of the paragraph, the 4-stage test that the court sets out. There must have been a mistake. We say that's clear.
Sorry, can I just ask, how do you define the mistake in this case? Is it one particular mistake?
Yeah. Well, the one that I'm focusing on is the question of whether or not post offices generally.
It's the generality point.
Yeah. But they're not open on Sunday.
Yeah.
The fact must have been established in the sense that it was uncontentious and objectively verifiable. We submit that it's not seriously in dispute that post offices are not universally shut on Sundays.
Yeah.
Thirdly, the appellant or his advisors must not have been responsible for the mistake. And you'll see from the transcript the way that the hearing develops. The appellant could not have known in advance that the fact it was posted on a Sunday would be elevated to such a central issue. Because if post offices are not universally shut on a Sunday, he would not be able to anticipate that this would have been such a bone of contention. So it's not, in my submission, his fault or his lawyer's fault. It And then fourthly, and I touched on this earlier, the mistake must have played a material, not necessarily decisive part in the tribunal's reasoning. Now, it's in my submission probably clear that it was at the very least material to their decision. And so, really, the nub of this case as I began is that there's been something's gone wrong.
Yeah.
There was an unfairness, a mistake of fact, an incorrect taking of judicial notice. It doesn't really matter from the appellant's point of view how it's framed, but it went wrong and it ought to be rectified immediately.
Suppose, and I'm not saying we agree with any of what you've said, because obviously we need to hear what Mr. Garris says, but suppose we accepted what you've submitted up to a point. Suppose we accepted that it does meet the 4-stage test in E, and it was a material error of fact, because it doesn't have to be decisive. Material presumably means, as it often does in public law, something which might have made a difference to the outcome. Suppose we were with you to that extent. That might suggest that the appropriate remedy then is to remit it, so that the actual issue of fact of whether this particular post office was open on that date, and whether this particular applicant did in truth post the claim on that day, it can be fully examined by a tribunal of fact. So that's subject to what we may hear about how it's not, we can be clear what the answer will be. But so that's why I want to hear what your submission is on your case.
Yes.
So before we hear anything from the respondent, what should we do?
Well, I think it would involve this court's analysis of the other reasons given,
Yes.
because the question of the materiality of this very central,
Yes.
the sort of spectrum of materiality from immaterial to determinative would depend on the other reasons that have been given. And for the reasons I've set out already, but also in my written submissions, that they didn't amount to very much at all.
That's right, but the proposition that not all post offices are always closed on a Sunday does not necessarily lead to the conclusion that this particular post office was open on the 26th of March.
Yes, I accept that as a matter of the project. Yes,
That's all I'm saying.
yes. I mean, I see the force depending on where the court ends up. I can see the logic and fairness of a remittal. Obviously, that's in second place in our scale of desirability.
You've made that clear, and I understand that submission.
Just very, very briefly, my lord, just in terms of the new evidence, what you have essentially is a bit of a game of tennis that's happened. The respondents put in some evidence from essentially an email exchange from the Chelsea big souvenir shop, Chelsea Pensions Hospital souvenir shop, and some other evidence from my own friends instructing solicitor as to interrogation of various websites. What I say at this stage is there's quite a lot to be said about that evidence and its quality and whether or not it could be undermined in a proper hearing. And I've set that out within the supplementary skeleton. I don't think it necessarily would be a very productive use of the court's time if I was to rehearse that now, because my principal submission is that is one line, which is that whatever view the court takes of that evidence, it can't be satisfied that it is determinative of the underlying issue in this case. And it would only be if it was inevitable in these circumstances that the tribunal would reach the conclusion.
So can I just be clear, Mr. Lee, that so far as the appellant is concerned, you're not inviting us to look at any fresh evidence at this juncture. It would only be, is this right? If they're going to be shown evidence from the respondent, which is post-decision,
Yes.
then you will submit that in fairness we ought to look at evidence from the appellant's side as well. But you're
Yes.
not positively asking us to look at it. Is that
That's
right?
exactly right, Michael.
Yeah.
Yes. We say all you need to do is look at the judgment and what's said for them,
I see.
unless I can assist you.
Well, that's been very helpful, and you've kept to your time, although there have been some questions from the bench, so I'm grateful to you. May I check if my lord has any?
One question. The prejudicial effect of the decision on your client, can I make sure I've understood that? If the decision stands for the sake of argument, what would he be able to do?
From his immigration status point of view, yeah. So it would mean that he would have been here essentially unlawfully since the date of the decision to refuse his application for further leave. And
As an overstayer,
it would mean that technically committing a criminal offence during that period. It would mean he'd have to leave the United Kingdom and subject to, in terms of the letter of the law and the respondent's position, he would have to apply from abroad in some way to rejoin his family in the UK.
would that be the same sort of application as
It couldn't be, as I understand it, couldn't be the same application that was made and refused previously, because the I think that route is open any longer. But certainly he would be
as a dependent under the the OBR scheme, sorry.
I'll double check the precise position, but I think there are difficulties in that particular route. But he would certainly have to prosecute any application from abroad. And underpinning this, and I think
It's not that he wouldn't have an ability to make an application at all.
well, you can make an application, whether it be successful or not under the current rules is a different question.
And would the fact that he would, by definition, then be an overstayer, would that fact be simply neutral on a further application, or do you submit that that would have some detrimental impact?
So under paragraph 9, I think, of the immigration rules, there is a series of factors which have to be taken into account by the decision maker, one of which includes previous breach of immigration laws.
I see.
And that there are various sorts of time bands. So I think the standard for somebody who's breached immigration rules is a year before they can re-enter. This is not a subject that I have prepared endlessly, but I'm talking from sort of general knowledge.
It's because prejudice is relied upon.
Yes, I mean, the other factor, my lord, is that, of course, what the Upper Tribunal found was that he had a good claim. So he had a good claim that his argument that...
An arguable claim.
Yes, he had an arguable claim, a viable claim, that the policy that he relied on did mean that he should succeed in his in-country application. So the consequences are on any view that he would be plunged into significant uncertainties to his ability to continue in the United Kingdom in circumstances where he has an argument that gets over the threshold that he ought not to be met.
On the other hand, there's a reason why there are short time limits for judicial review. And one of them is to protect the finality of public authorities' decisions. And effectively, a shield is removed from a public authority every time there's an extension of time granted. A year or more has gone by, and they and the public interest they represent can otherwise be confident that a decision is to be regarded as valid in law.
Yes, and it's really, I would sort of pronate the way Lord Justice Stuart Smith put it, which is that one looks at all of those factors, they look very different depending on the underlying factual circumstances. So if this appellant did attempt to lodge his claim in March 2023, that is a very different set of circumstances to someone simply rocking up 14 months later and trying to lodge a claim then. In the latter circumstances, all those factors that my lord mentioned are perhaps almost insurmountable. It's a bit different in the first example, because there you have somebody trying their best within the system, and the prejudice to the respondent is lessened by that, in my submission, because he's trying to get his ducks in a row.
But following on from my Lord's question, isn't this an aspect the Upper Tribunal took into account at paragraph 14 of their decision, page 277 of the electronic bundle?
Is this the point about chasing?
Well, partly. It starts with the words, even if he did, which assumes in his favour that he did make a timely application. He did nothing to chase it for more than a year, etc. Yes, it is that point.
Yes,
That's why it all raises.
so I think there's a similar answer to that as to the one I gave to my Lord a few moments ago, which is that, again, the tribunal proceeded on one, their finding was pretty clear, they weren't satisfied that it was sent. And that necessarily does two things. One, it infects their general view of the appellant. So the reasons for not chasing in my submission are necessarily infected by that. But also, it's very different. If he did lodge this claim, and the only thing that can be said against him is he didn't chase it, if one's applying sort of Denton and High Sarge to that scenario, it's actually quite difficult to see what rule he broke, because he is lodging his claims he thinks he's supposed to. He doesn't know the system particularly well. He doesn't chase. That's not a breach of any particular rule, practice, direction, or authority. So applying, as we're told to, the Denton, the Mitchell approach through the lens of High Sarge, the judicial review jurisdiction, that's a very, very different analysis if he lodged but didn't chase, in my submission.
Well, aren't there two rules potentially in play? One in the tribunal was Rule 28, the application has to be received within 3 months' time limit. And secondly, in an immigration case, there's a requirement on the applicant to serve the papers on the other parties, and within 9 days to tell the tribunal that they've done so.
Yes, as I say, I'm not suggesting that
Those rules are in play, aren't they?
I'm not suggesting that there's nothing that can be said about that. But it is a very different factual matrix in my submission. If someone has lodged their claim and has said that what the criticism is they haven't chased it, the factual finding in this case, essentially the central factual finding, is you never sent it.
Yeah, you're entitled, I think, to make the submission that, taking the reasoning of the tribunal at face value, that's what they focused on at paragraph 14.
Yeah.
That he didn't chase it. They didn't, for example, as they might have said, they didn't say, as they might have said, that he breached a further rule, which was the requirement to serve the documents on the Home Office within 9 days.
Yes.
Now, it may be speculation about that. What would they have made of that if they had been thinking about that? But we'll hear what the other side say about that.
Yes, I mean, this was correct. What they say is, we take into account you didn't chase. And my submission is that that's what's left in the factual. The claims lodged but not chased.
Yeah.
In my submission, that is a very different scenario.
Thank you. Thank you very much. Yes, yeah.
I'm grateful, my lord. I wonder if I might be able to trouble either my learned friend or to step forward and grab a lectern.
Please take it.
My lords, the structure of my submissions will essentially be to outline the argument that, in fact, what has happened here is not that judicial notice has been taken. And then, as my learned friend helpfully heralded, to say that even if it was not material on the outcome of the Upper Tribunal's decision, even if it might be material on the reasoning. The outcome would be the same in this case, and that does rely on some of the additional evidence that postdates the tribunal decision in this case. but broadly speaking, it's those two headings. And I'll start exactly where my learned friend did, with the transcript of the hearing.
What page is it in the electronic bundle?
I will. What I've got the page numbers of the hard bundle. So it's 318, and from memory we add 22 at this stage, so 340 electronically.
Yeah, I'm certainly in the transcript. Though.
In the transcript, but yes. So on paginated page 318, electronic page 340, we're 7 or so pages into the transcript.
And which line?
And if we start at line 8, this is a little bit from Judge Perkins, where he talks about what's been bothering us. So Judge Perkins there says, there are things that are bothering us very much about this service, Mr. Georgia. We are very unhappy not having an explanation before us for the choice of post office. We also find it surprising that the date on the pleadings and the date of posting is the same. Again, that is by no means impossible, but it must be, if the dates are right, that he was preparing the documents whenever and then going to hospital the same day and posting it. Not impossible, but we do not get it. I mean, it may be something very obvious. It may be he's got a close friend who lived nearby and he was staying there or something, but we do not know. It is odd. The date itself is worrying us as well, and then a square bracket, inaudible, go into it if we have to. All right, we will leave it for now and see what Mr. Yarra has to say, but we may return to this because it bothers us. So this is the part earlier in the hearing during which Mr. George, for the applicant, is making his principal submissions about the judicial review in general, and also the application for an extension of time. And it's before I'd given my submissions on behalf of the respondent at that stage. And then we go to the part that my learned friend took you to, on page 324 in hard copy.
So what's that in the electronic bundle?
Electronically 346, my lord.
On that. Seems to have gone to 373.
Ah.
We'll go back to 346.
346 electronically, and it should be paginated in the bottom right hand corner at 324. And forgive me, my learned friend didn't actually take you to this particular bit, but this is the bit that heralds the taking of evidence. So right at the bottom of page 324, lines 34 and 35, Judge Perkins says, all right, the other thing that is troubling us is this certificate of posting. Are you in a position to give better evidence about that today? And then we go on to the next page, and Mr. George says, yes, we can call the witness. And that's where he gives evidence. Now, just to provide a little bit of context, the application for judicial review that was lodged in April 2024, the one which was received by the tribunal and which led to this oral permission hearing, there was an application made for an extension of time before the permission refusal on the papers by Upper Tribunal Judge Norton Taylor. And it was said in the application for extension of time, please see the certificate of posting. But that was not provided with that application that went before.
That was a point the judge made in his order.
Pardon me?
That was a point made by the judge in his order.
Yes, so Upper Tribunal Judge Norton Taylor, in his order refusing permission on the papers, made the point that they said there's a certificate of posting, but I've not seen it. Yes. The certificate of posting only appeared with a later application made by the appellant 8 days before the oral permission hearing. So that's just to provide a bit of context that the evidence which now the tribunal were calling the appellant to give orally was evidence that had been provided by way of an application dated the 1st of October. That is in the bundle, my lords. Let me, because the pagination, do forgive me, changed this morning, my map of the documents.
I think it may be 128 in the electronic bundle, so if we add 22, or 129, the index doesn't tally with, it's 100, maybe 129.
129, yes, and 129. So if we, which electronically is not this stage. We don't add the same number of page numbers. It's 153, my lord. Electronically 129 in page numbers. Pardon me?
Just bear with me.
Of course, my lord.
129.
129.
That's an application notice without consent.
Yes, my lord, that's the one. So this was the application notice that followed the refusal of permission on papers, followed the renewal application,
Got it. Yeah.
and was made on the 1st of October 2024. And it was an application for permission to adduce further evidence not filed with the original claim. I'm looking at page 132, section 3, details of the application. And the first part of it was evidence of the policy, and the second part was witness statements from the applicant, now appellant, and his current solicitor, with accompanying exhibits which relate specifically to the issue of timeliness and to facts of which neither the tribunal nor the Secretary of State have so far been made aware.
But it's not unusual to have some further evidence before the renewed application for permission to bring a claim for judicial review.
No, my lord, you're absolutely right. It's not unusual, but it was problematic in this particular case because, in this case, the original grounds for judicial review said that the prior application for judicial review was lodged on the 10th of February 2023. So the first representation of the date when it was first posted was the 10th of February 2023. Then there was a later representation that it was the 20th of March 2023, which is a Monday. In fact, the Monday before the 26th of March, which has now become of issue in these proceedings. And this application, 8 days before the oral permission hearing, was the point at which the certificate of posting, which is now of such central importance, was first provided, when it ought presumably to have been provided previously, and indeed Upper Tribunal Judge Norton Taylor was surprised that he did not have it. It was that's to provide context as to why it was that at that hearing in the Upper Tribunal judges appeared to be quite troubled by what was going on with the certificate of
just
service.
made is what the paper judge described as a discrepancy point in his reasons. Paragraph 7 is page 272 of the electronic bundle.
Yes, my lord, 295 electronically. Paragraph, my lord, 7.
Clear and unexplained discrepancy here.
Yes, and indeed, while we're here on this order of the tribunal, if we look at paragraph 8, we see what I've just been referring to: the proof of posting being attached. However, I cannot see any such evidence, and interestingly, in paragraph 9. Upper Tribunal Judge Norton Taylor's view about the non-chasing was not, as it were, a promptness point taken against him in respect of what my lord has just been working through with my learned friend. But actually, if we look at the final sentence on in paragraph 9 of Upper Tribunal Judge Norton Taylor's decision, he uses it as a way of as an ingredient into the fact-finding exercise, where he says this unexplained and significant inaction is indicative of the original UTIAC 1 application form not having been sent in as claimed.
But that's not the way the Upper Tribunal.
That's not the way the
Yeah,
judges dealing with it in the oral permission hearing did, which was more in the promptness.
I think we have to keep in mind that this is an appeal against the decision of the Upper Tribunal after the hearing.
Of course, my lord. I'm not trying to import this in. I'm just trying to provide context into what's in front of the Upper Tribunal at that stage,
Yes.
what documents they're thinking about and looking at, which leads them to become troubled about whether or not this original claim was in fact sent on the date on which it was said to have been sent. These are documents which were before the Upper Tribunal. So if I could return, pardon me, to the transcript.
What page should I type in now?
If we now go to type in will be, I think, 351,
Yeah, got it.
which is the bit that my learned friend has already taken you to, my lord, page 329.
Okay.
And this is the bit where I do make that submission to invite the judges to take judicial notice.
Is it right? You did not ask to cross-examine.
That's correct, my lord.
So the point that's made against you is, well, he's just given evidence. Was it on oath?
Pardon me, my
Was it
lord.
on oath?
I believe so, my lord. I'm afraid I can't
Yeah.
remember.
That's how witnesses usually give
Yes.
evidence, either oath or affirmation. But anyway,
But
it's not just a statement. Anyway, so he's given evidence that he posted it on that Sunday, and you did not cross-examine him on that.
no. And then I do make that submission, take formal judicial notice of the fact the post office is not open on a Sunday.
Yeah.
And then Mr. Georget objects is a strong word, but he says, interjects at that point, says, I'm not entirely sure that's right. Judge Perkins says it's a submission, etc. But the next interjection of Judge Perkins at line 26 is important and illuminating, because Judge Perkins says, I think it's entirely contrary to our experience. I am not sure it is within the scope of judicial knowledge.
Yes.
So he expressly says at that point, contrary to our experience, but not sure it's within the scope of judicial knowledge. And that phrase is important because what comes into the reasons that we see in the order that we've already looked at is that exact phrase that Judge Perkins uses at this point. In our experience, post offices do not open on a Sunday.
But if that's not judicial notice, what is it? Why is he referring to our experience? I mean, when I sit as a judge, and there's any issue of fact before the court, I don't take account of my own experience unless it's relevant to the question of judicial notice.
Well, the question is what is the if it's taking judicial notice of something outside of the evidence heard in the courtroom, i.e. the experience of the judge,
Yes.
what is the fact that is being found or appropriated by the judge at that point? What notice is being taken? And all that is being taken at that point is that the judges, in their own personal experience, have not encountered post offices open on a Sunday.
Yeah, but
It
that's
is-
not, sorry, forgive me.
No, of course not.
I don't want to interrupt you, but aren't they saying, eventually when they give their reasons, aren't they saying that post offices in this country do not open on a Sunday? That's a general proposition, and therefore, as a matter of logic, you can infer that this post office was not open on that Sunday?
My lord, no, that's what they're not doing in this case. What they're doing in this case is saying they have not experienced post office being open on a Sunday. But what they do not say is, as a statement of fact, as a proposition of fact, post office are not open on a Sunday, therefore this post office was not open on a Sunday, therefore this certificate of posting is not genuine.
If that's right, then why is their experience of any relevance? Because it's not in evidence.
Because it's about a probabilistic assessment of credibility of the applicant based on all of the factors before the judges in the courtroom. If they had made a finding of fact on judicial notice that post offices do not open on a Sunday, if they had made that finding, that would have been the end of it. There would have been no need for them to have written a single further sentence, i.e. to go into any of the further detail that they did. So my primary submission is that's actually not what they were doing. I asked them to do that, and I accept I asked them to do that, but they didn't do it. They made a generalized credibility, probability-based assessment of whether or not they thought it was true or not that this applicant had sent his certificate of posting on the Sunday. And they drew from their experiences of them not encountering post offices open on a Sunday as part of that inherent probability exercise.
But suppose you're right about that. Suppose it's not, strictly speaking, an example of judicial notice being taken. Then could it not be said that it's simply irrational? Because if you infer from your general experience to the specific facts of a particular case before you, without having any evidence about this particular post office on that particular date, why is that rationally sustainable?
Because it's not it's an ingredient of the decision-making exercise. It's not the crux of the decision-making exercise. That's what I would say. And it's perfectly rational in my submission to consider a factual narrative to be inherently more plausible or inherently less plausible, depending on the probability of a real-world event taking place or not taking place. They've not made the finding of fact. What they've done is they're analysing the likelihood of something using a number of ingredients. If this was a weekday, it wouldn't have had any bearing whatsoever. Because it was a Sunday, it had some bearing, because as a matter of probability based on their experience, it was less likely to encounter a post office that was open on a Sunday than if it was a Tuesday. And that was a legitimate thing for them to be able to do. In any case where judges are performing evaluative exercises, they can consider the inherent probabilities of the narratives. No matter the type of case, there's often bits of inferences from the real life world of judges that find their ways into judicial decision making. But it's an ingredient here. It's not the crux of it. It makes the account less likely. And there are a number of other reasons why the judges found the account not to be likely. And I pointed out the bit earlier in the transcript which demonstrated the areas of concern, namely being in Ilford, printing and signing the document in Ilford on the same day as then travelling to the opposite side of London with the papers to post them at a post office. On its own, not necessarily something that could never occur or is inherently implausible, but it's an ingredient into the credibility narrative. The part about keeping the certificate of posting in an assiduous and diligent manner, and yet not chasing up at any stage what was going on in the 13 months after that, having sent it, and also not having sent the post recorded delivery or by some other means that would marry with the keeping of the certificate of posting more neatly. Again, not inherently implausible, but it's an ingredient into the narrative. And then they heard from him directly, and he gave his evidence directly. They questioned him about it, and so they were in the atmosphere of the courtroom. And I've cited the Clinton and Walter Lilly case there for the many principles with which this court will of course be very familiar about the judges at first instance who hear oral evidence having the advantage over an appellate court when it comes to questions particularly of credibility. Because if one is considering whether or not a narrative is believable, pardon me, my lord.
No, we are very familiar with that,
course.
but also in recent times, courts have urged some caution. It used to be said, for example, well, you can rely on something called demeanour. But I think that a more modern approach has taught us that there can be risks associated with that, and that you often test the credibility of a witness by reference to some objective factor rather than simply a subjective appreciation of how they look or appear in the witness box. So, for example, it's frequently emphasised that you look for contemporaneous records to see if they are consistent with what the witness is saying or contradict what they're saying, things of that sort.
Yes.
You have to be very careful because we all have unconscious biases, one of which can be how we think a truthful witness behaves. And in the criminal courts, where both of us have a lot of experience, it's for decades it's been emphasised that eyewitnesses, for example, can seem very credible witnesses and turn out to be completely wrong.
Yes, man. Of course, and I would not be saying that it's impermissible for this court to review the evidence based only on the transcript. The larger point I'm making is more that there is the advantage here for the Upper Tribunal who are apprised of all of that information. Island hopping is one of the phrases that's used, of course, in that Clinton Walter Lilly case. But they've got these documents. They're aware of the fact that we've got a second application 8 days before the hearing, and this is the first time the certificate of posting has been produced, notwithstanding it's mentioned in the judicial review claim back in April of that year. They've got the applicant in front of them. They've heard the evidence live, and so there is an advantage in that sense. And it's in all of this, as I keep repeating myself, but these are all ingredients into the decision making. Nothing here is a finding of fact. This post office was closed, because if they'd made that finding of fact, that would have been the end of the story.
But do you accept that they made a finding of fact that the claimant did not, in fact, post the claim on the 26th of March, as he asserted? And do you accept that?
They made the finding that he'd not come up to proof on the allegation which he had proffered. He proffered an allegation. I posted this on the 26th of March 2023, and they found they were not satisfied that he had proved what he had asserted to prove.
Yeah, but that's fine as an answer, but the common law takes the approach that if you haven't discharged the burden of proof, it didn't happen.
Yes, ma'am. So to that extent, yes.
And do you accept that they were making a finding of dishonesty?
No.
No, you don't.
They were not making a finding of dishonesty, and that would be very clear if that's what they were doing, because what they have said, they've used their language very carefully. They've said we are not satisfied that it was sent. Don't say anything else about why that might be, whether the document is a forgery, whether he had assistance from somebody and it was an innocent mistake, or whatever it might be. They are absolutely not, and that's clear on the face of the order, making any finding of dishonesty with respect to the appellant. And indeed, as my Lord Holgate has already said, in paragraph 14, they even consider the counterfactual scenario, even if it were right, and they used that phrase, even if it were right that he sent it. He did nothing, and so they look into the analysis on the other side. Again, if they were making a finding of dishonesty, they would not have framed the order in the way that they did. Pardon me, my lord. I'm referring back to my notes. Covered that off. My lords, I think that's where I want to finish on submission one, i.e. the judicial notice is not what's happened in this case. The second main heading of my submissions is if there was judicial notice of a fact, it was not material. And I say that because the evidence, the new evidence, shows that the post office was in fact closed on Sunday, the 26th of March.
So would you like us to look at that evidence without admitting it at this stage? Because as I've indicated to Mr. Lee, we're content to look at anything that either side wishes us to look at, and we'll decide in the course of giving our overall judgments whether it's admissible or not.
Yes, my lord. That would be a perfectly sensible way of proceeding. If I may, I think the evidence which came in with the appellant's notice and the evidence from the 30th of April 2025 being the letter from the Mr. M. Patel, there's almost a quid pro quo, evidence on their side, evidence on our side, one each, that is, I think, generally certainly accepted on our side, and I think accepted on the other side as a broad proposition that there should be one bite at the cherry on each side. It's the second bite of the cherry on the appellant's side that I take strongest issue with in terms of admissibility.
Well, I may be wrong, but so far this morning, I don't think I've been shown any evidence that was not, that postdates the Upper Tribunal decision.
No. And that's where I intend to go next. And I think my learned friend suggested he might deal with it by way of reply. But because it's my second submission about materiality, this is where I will now go to try and make that submission good.
I'm not stopping you. In fact, I'm encouraging you to show us whatever you want to show us. All I'm saying is Mr. Lee hasn't shown us anything which postdates the Upper Tribunal decision. So for his part, in opening the appeal, he has been content simply to rely on the evidence that was before the tribunal below. Yes.
But I think I need to make my secondary argument on materiality. So the starting point, my lords, is the oops, pardon me, which we probably need to cover off. However, is the issue of the screenshots, because it's not accepted by the other side that those were not, if that's not too many negatives, that those were not shown to the judges at the time. We say the screenshots were not shown to the judges. As far as I understand it, the appellant is still in this case saying that the screenshots were shown to the judges. There's a witness statement to that effect. Obviously, the witness statement. It's one that postdates the decision, but it's
which witness statement?
It's one that was filed on Thursday or Friday of last week from the appellant.
Is this Mr. Baparee's witness statement?
Yes, my lord. Yes.
I'm not sure it goes that far. Still.
Well, if you're going to refer us to something which is a document, I think you've got to look at it.
Okay.
And look at it together, wherever, and take your time, because as I said at the outset, we all need to make sure we're looking at the same page at the same time. So if you just tell me how I find it, where I find it.
So it's 200, according to the index, it's 280.
So what should I type in?
I'm just going to, here we are. I found it. So, my lord, it's 281 hard copy and 303 electronic.
Has 1148 in the top left-hand corner?
Yes, my lord, yes.
This is a screenshot.
This is a screenshot that shows as of 11:48 a.m. on the 9th of October 2024. It shows Google Maps, which is what the application is here.
Sorry, I haven't seen the date yet. All I'm seeing is a time.
Towards the bottom of the screenshot on 281, there's Wednesday, 9th of October 2024. And that says at the top, post office and gift shop, brackets RO, and then open now. And it has, in respect of Sunday, opening hours 9 a.m. to 5 p.m. 282 is a further scroll down of the same information, as is 283.
And you could be making several points about that, but I just want to be clear what the submission is about this screenshot. First of all, it wasn't before the Upper Tribunal judges.
It wasn't before the Upper Tribunal judges. Is our well, I don't know whether to call it a submission or evidence, but because we have got a witness statement from those behind me, and of course I can't give evidence, but our argument begins on the premise that this was not shown to the Upper Tribunal judges. If it had been, it would have been almost absurd for them not to have mentioned it.
Okay, but if otherwise it's admissible, I'm not saying it is, but if it is, so far, do you have submissions to make about the contents of the evidence?
Yes.
And what do you say about the contents?
So what I'm doing first is putting the appellant's case at their highest first. So these screenshots and the letter from Mr. Patel are the appellant's case at its highest as to the opening of the
Where's you say screenshots plural? Do you want us to look at any other screenshots?
It's these three in a row: 281, 282, and 283. These are all. If you recognise the format from the Google Maps application, and the last one on 283 is of some relevance because if we look at page 283, one can see that the website from which Google Maps has obtained its information is chelsea-pensioners.co.uk.
Sorry, I'm just looking for that. I'm not sure I am seeing that actually. Where do I see that?
283, underneath the word suggest new hours, there's a global icon and then website chelsea-pensioners.co.uk.
So that's the website from which this information is derived.
That's what I say, yes.
Okay, I understand that. And then you mentioned Mr. Patel's witness statement.
Mr. Patel's letter first. He has now, in fact, produced a witness statement.
Yeah, but you mentioned the letter. What page is that?
That's just prior on page 280 or 302 electronically.
Let me just go back to that. This is 30th of April.
30th of April. So this was immediately prior to Lord Justice Stuart Smith's decision on permission to appeal.
What's not clear from the bundle is how this comes before the court.
No.
I mean, your solicitor in her witness statement explains, I think, Well, in fact, Lord Justice Stuart Smith asked a question about the screenshots and what I think the date was, and that's deals with this in paragraph 11, and she says these screenshots were taken on the 9th of October on the hearing date. They were shown to both the tribunal and the respondent's counsel, and then she goes on to refer to what Lord Justice Stuart Smith said in granting permission. Were the screenshots just simply sent to the Court of Appeal?
The screenshots came with the appellant's notice, I believe. The first time we saw them...
sorry, there are many notices in this case. You
yes.
need the appellant's notice seeking permission to appeal.
Yeah, I believe so. The first time the respondent had any sight of this was when we got the order saying permission had been granted. But I believe the screenshots were originally with my learned friend's Grounds and Skeleton when they were first sent in November 2024. The letter from Mr. Patel, however, wasn't, and I'm not sure how that got before the court.
That's what I was finding difficult to follow. I mean, it's eventually referred to in one of the more recent October 2025 witness statements.
Yes. But it's referred to, if we go, in fact, to Lord Justice...
Sorry to interrupt.
Of course, my lord.
That the Patel letter wasn't before Lord Justice Stuart Smith, just the screenshots.
No, so, pardon me, my lord, if I'm confusing. Lord Justice Stuart Smith has the letter because he refers to it in his order. Perhaps we can go to it.
Sorry, my fault.
It's page 284 hard or 306 electronic.
This is the grant of permission.
Yes. And so the first point is the screenshots, and that's paragraph 4. And it says, these reasons were given despite the tribunal being shown, brackets, so I am told,
Yes.
2 screenshots which showed the opening hours of the post office to include opening on Sundays. So we say that's actually not true, in fact. The tribunal judges were not shown those screenshots. So the so I'm told from Lord Justice Stuart Smith is important there because he was told by the appellant's solicitors on their instructions that these screenshots were shown to the judges.
Yes.
And it's an ingredient into his decision on permission.
Yes.
Because he then, at paragraph 5, says, in these circumstances, it's arguable there's no rational basis. But then, in answer to my lord, there's a mention of the letter. If we go right to the bottom of, well, in fact, it's onto the next page, on the information for or directions to the parties. The respondent should indicate A, whether it now agrees that the post office was open, and B, whether it agrees the contents of the letter dated 30th of April 2025 addressed to the court. So the letter's addressed to the court, so I don't know whether it's arrived with the court by some other means, but it's clear that Lord Justice Stuart Smith has it, and he invites the respondent at that point to indicate its position. Now, my lords, you may have seen from the respondent's notice in the bundle, there was a bit of a, I don't know how to phrase it best, but there was a bit of a muddle with respect to the respondent's notice. But what the respondent initially did was put in effectively a holding response saying we're urgently investigating this position because we're not quite sure about any of this. And then later, the respondent filed an amended respondent's notice and the witness statement of Ms. Farrers, setting out the position of essentially an answer to these 2 questions.
So where do you want to look next?
So if we look at the letter from Mr. Patel, because the 2 things I wanted to say were about what the appellant's case on the post office being open at its highest was first. So we've looked at the screenshots, and then if we look at the letter from Mr. Patel on page 280.
Yes.
It's dated the 30th of April 2025. And he says, I'm writing on behalf of Chelsea Post Office that until October 2024, we were open 7 days a week from 9 a.m. to 5 p.m. Doesn't say when that started. The until October 2024 doesn't have a beginning date. We confirm that the stamp shown on the envelope dated the 26th of March was from this post office. We also allow customers to take photographs of their envelopes as proof of posting. We've now shifted to a new address. please feel free to contact us if you have any question or require further assistance regarding the matter.
Yeah.
So it's phrased as we from the post office. It's not I confirm this, I confirm that. So when it says please feel free to contact us, that's in fact exactly what the respondent did. The respondent then attempted to contact the post office with further questions arising out of the above. But this is the appellant's case at its highest, that this particular post office was open on a Sunday, that the Google Maps application showed what it thought was the gift shop and post office to be open on a Sunday in October 2024, and that a letter from a Mr. M. Patel, not on headed paper in this form that we see it in, indicated that it was open on a Sunday. That's the appellant's evidential position at its highest on the question of whether this post office was in fact open. So what the respondent then does is respond to the order of Lord Justice Stuart Smith and respond to the invitation in Mr. Patel's letter to contact the post office and makes inquiries as to what she understands the factual position to be. And that leads us to the witness statement of Ms. Farrers, which is at page 303, paginated 325, my Lord Justice Singh, for electronic.
Yes, thank you.
And she sets out some of the background to the case, and pardon me, it's just minimized. And in paragraph 7,
Yes.
she speaks about not having been at the hearing. So she wasn't there at the hearing, but she explains the transcript and that he was there giving his oral evidence. And then in paragraph 13, she gives the evidence which I've already advanced earlier, where I said it was slightly grey as to whether it was a submission or an evidence. But she says, to the best of my knowledge and belief, it's incorrect to state that the screenshots were shown to the Upper Tribunal. Nothing in the transcript. She mentions a single reference on page 18, which my Lord Justice Holgate has already indicated. I've been Googling for that, but nothing further. And
well,
she was...
There's also the point that there's an application to treat this as new evidence.
Exactly so, and that she mentions that. Maybe that goes into submissions or argument at this stage in the statement, but she does mention that, exactly that even in the grounds of appeal and in the appellant's skeleton argument, this is referred to as new evidence. So I'd invite the court to find that the screenshots were not in front of the Upper Tribunal, and therefore to include them within the general milieu of evidence which postdates rather than predates the judgment under appeal. But then at paragraph 15, we get into the heart of what Miss Farrers then does, which is she goes looking into the facts as to this particular post office, and she does it by way of internet searches.
Yes.
And she finds, and I'll just highlight what she finds now before we look at actually the documents. She finds at 15A of her witness statement a URL of the chelseapensioners.co.uk website, which is the one that we saw from the Google Maps application screenshot, that has been archived using the Wayback Machine on the 21st of March 2023. So an archive of that website as it was 5 days before the Sunday in issue. And that web page, she exhibits to her statement, I'll go to it in just a second, and that indicates that the post office was closed on weekends. And then at B, she also finds a publication from the post office published online, which explains the relocation of the post office within the hospital in September 2024. And it says, the document she's found, the PDF says, the post office branch is scheduled to close on Thursday 29th of August 2024 at 4:30. And the new branch is scheduled to open on Tuesday the 3rd of September 2024 at 9 a.m. And in respect of opening hours, it listed new opening times, included that the post office was closed on a Saturday and Sunday as of September 2024. Now that date is relevant because it contradicts what is shown on the Google Maps screenshot, and it contradicts what is said in Mr. Patel's evidence, which is that until October 2024, the post office was open on a Sunday. That's why these dates, although they're after March 2023, they're
Before the 9th of October.
it's before the 9th of October, and it directly contradicts what is shown in the screenshots and what is said by Mr. Patel. And now having gone to those two paragraphs, I can show you the documents. The archived website from March 2021 using the Wayback Machine is at page 334 in hard and 356 in soft. And it might be a little bit difficult to read in hard copy.
My bundle ends at 351.
Does it end in 351 electronically or in numbered page numbers?
Numbered.
Okay, so hopefully you'll have 356 electronically and 334 paginated in hard copy.
334 is what I'm looking for, is it?
In the bottom right-hand corner, my lord, yes.
Let me just find that. Yes. Now, what's this?
So this is, it's probably easier to read on the screen than it is in hard copy.
Is this exhibit FF05?
It is, my lord, yes.
Which is what she's referring to in her witness statement at paragraph 15A.
Yes, my lord, exactly so. It's an archive
But even
of...
if we can't read it, unless this is challenged, this is her summary of it in her witness statement.
This is her summary of it in her... Pardon me, my lord, yes.
Yeah.
And what it shows is that it's closed on weekends. And we can see the archive date at the top right-hand corner, if one can read it that small, 21st of March 2023.
Yes, I see.
So that's the 15A document, my lord, and I'm sorry I didn't just say that straight off the bat. The 15B document is at 335, the very next page. And that's rather than being an archived web page, that's actually a PDF, and it refers to those dates on it that I've already spoken about.
Was this evidence in existence on the 9th of October 2024?
As a matter of public record, yes, my lord, it was.
Why could it not reasonably have been adduced before the Upper Tribunal?
Well, I agree with my learned friend that in essence the fact that it was a Sunday only arose as a central concern in the case for the first time at the hearing on the 9th of October. And at that point, I suppose the options were to adjourn the hearing and go away and investigate the position, or to proceed in the way the Upper Tribunal did with the information they had before them.
At the date when the parties attended before the Upper Tribunal, what they had to go on was the certificate of posting.
Yes. And I think it was the Upper Tribunal's own interest in the question that led to the inquiry into the fact that it was a Sunday. And then the other thing that Miss Farris did, as well as doing this internet search and finding those documents I've just shown you, if we go back to paragraph 16 on page 306, as paginated.
Sorry,
Page 306.
thank you.
We're back in the witness statement.
Paragraph 16.
Paragraph 16, she explains why it might be possible that the Google Maps application has got the opening hours wrong. And she explains that because the website is shared between Chelsea Pensioners Gift Shop and Chelsea Pensioners Post Office. And I don't intend you to take, my lords, you to the exhibit that she demonstrates that that's the case. But it's, as you say, my lord, if it's challenged, then we can address it. But otherwise, what she says in the witness statement is a summary of it. And then paragraph 18 of her witness statement, she talks about the inquiries that she made with the post office. So she got in touch with the Royal Hospital Chelsea, spoke to a member of staff named Kimberly. Kimberly informed her that it was her understanding the post office had never been open on a Sunday, but referred her to a person called Esther, who worked in the shop. Esther was contacted and she provided her response that's summarised at paragraph 20 of the witness statement. And paragraph 20 says, after the call you had with my colleague Kimberly and the following conversation with our director, we can reassure you that the post office at the Royal Hospital Chelsea was never been opened on Sunday, March 26th, 2023. But she was unable to talk about the certificate of posting, so she referred the question to a member of staff called Manish, and she was told that the certificate of posting had been discontinued a while ago.
Could it be said that this is at least multiple hearsay evidence?
Of course, my lord.
Whereas what the claimant gave in evidence on oath or affirmation was his own direct evidence.
Yes, my lord.
Now, there may be a conflict there,
Yes, my lord.
and it doesn't necessarily mean that a tribunal of fact is bound to accept his account. But what does this all amount to? I think you say there's only one inevitable conclusion.
I say that is how I present it, is that as a fact, this post office was closed on a Sunday, and therefore, in the alternative, my primary submission in the main appeal, if there was an error of law by the judges in taking judicial notice of something they shouldn't have taken judicial notice of, it had no material bearing, because the actual fact that was relevant was not whether post offices in general are closed on Sundays. That wasn't the relevant fact.
Why should we? I don't mean any disrespect,
Of course.
to, I don't know who Esther is, who Kimberly is, why, even taking this all at face value. I don't think even on their face they purport to be giving direct evidence. They report their understanding of what was true on the 26th of March 2023. When you've got a conflict of evidence between, say, multiple hearsay statements on the one hand and direct evidence from a witness who may not be telling the truth, I grant you that, but nevertheless you've got on the face of it a conflict in their evidence. How does a tribunal of fact resolve that? I mean, we're not a tribunal of fact. We haven't heard any of these people. Isn't the better course for it to be remitted to the tribunal of fact so that it can sort out this factual issue once and for all with the best evidence?
Potentially so, my lord. I hear exactly what you're saying in terms of the hearsay evidence. I would suggest that the internet evidence, the internet-based search evidence is stronger, because that's contemporaneous documentation that's not, as it were, riddled by multiple hearsay. It's hearsay in a sense, because it's...
That's right, but I'm afraid that the experience of the court has been that the computer is not always right.
But when you're talking now about exhibits FF05 and 06, I assume.
Yes, my lord, just now.
Go any further than to negate reliance on the screenshots which purport to describe the position on the 9th of October?
No, they negate the screenshots and they negate the letter.
The 9th of October. Do they go back to dealing with the 26th of March 2023?
The exhibit FF05 does.
Okay.
FF06 deals with
Yes.
the position as October. FF05 deals with the position as 21st of March.
Explained in 15A. Thank you.
That seems to be your best evidence.
The best evidence is I accept is the internet searches over the multiple hearsay. I accept it. It has to be, but it counters everything that's said on the other side. It effectively cancels that out, which means I say this court can consider if it did remit it back to the upper tribunal, is there any other possible outcome? And it's a strong position to take, but my position would be no, that the outcome would be a finding of fact that this post office was closed. And that would mean that any error in respect to judicial notice would be immaterial.
It may not matter very much, but 11:48 on the 9th of October, was that before the hearing started?
It was in, as I understand it, it was in the break between the bit of the transcript we've just been reviewing and when we came back into
During the middle of the hearing.
hear judgment. So, well, after all the evidence and submissions have been made,
So once the question had been raised by the tribunal.
yes, I wouldn't want to be pinned to exactly that time, but it was my understanding that
As I said, it may not matter very much.
that's when that screenshot came into being.
Very good. Now, Mr. Yarrow, I don't want to curtail your submissions unnecessarily, but I do have to keep an eye on the clock. And
Yes,
we
ma'am.
need to leave time for reply.
Yes, my lord.
You've referred to quite a lot of new material, which obviously is going to make the reply longer than it might otherwise be.
Yes, my lord.
Now, how much longer do you need?
I'm content to essentially wrap up at this stage. For if my lords, you've seen my written submissions in response to the new evidence that came in on Thursday,
Yes.
which is an additional statement from Mr. Baparee and an additional statement from two more statements from Mr. Patel and an additional statement from
And in
the
a
solicitor.
nutshell, what do you say about those?
In a nutshell, I say that is now a second bite of the cherry. This should have, if that was the way in which this appeal was being advanced, while it might not have been doable at the 9th of October, it was certainly doable in November at the time at which the appellant's notice was first filed. And you'll see in my written submissions on that all the reasons why I say in any event it's not particularly cogent or strong evidence in any event.
Right.
And what it doesn't say, interestingly enough, the statement from Mr. Manish Patel, what it doesn't say in terms, expressly or implicitly, is the post office was open on that Sunday. In fact, the focus of the witness statement is on the certificate of posting, which in a sense, Mr. Patel could quite easily believe that the certificate looks genuine,
Yes.
but the evidence as to it being open on a Sunday is not front and center within the the first statement of Mr. Patel, the new evidence that's come in over the weekend. So to wrap up then, essentially you have my submissions, primary submission that it wasn't judicial notice, alternative submission if it was, it didn't make a material impact. In answer to one of my Lord Justice Singh's questions just now about what to do with it, you'll have seen in my written submissions that I put forward in answer to the application last week, that there is a possible route whereby this court effectively stays the appeal because it can't determine whether or not the error was material or not, stays the appeal and remits the factual question back to the tribunal for a determination of the fact, and then effectively any decision of this court would be contingent on what that finding was. But it would be a mechanism whereby not to allow the appeal and say, well, this is a material error of law, because that can't quite be determined until we know the actual facts about this post office. So it's a mechanism that this court could use rather than substantively determining the appeal. It's unattractive, of course, because no one wants to see this matter come back to this court. But as I say, a contingent decision could flow effectively. If the facts show that it was open, then X. If the facts show that it was closed, then Y.
Right, thank you.
My lords, unless I can assist with any further questions.
That's very, very helpful. Thank you.
Great.
Yes.
I'll be relatively brief. Can I just begin just by doing that last point, the suggested, suggested disposal of the appeal. This court very often will send back a case to the court below when it doesn't know what the final result's going to be. What it looks at is the question of whether or not, as I began this appeal, something went wrong in the judgment of the court below, and they ought to look at things again. And quite often, courts at this level will be careful about what they say, because they don't want to necessarily prejudice how things will go on, for example, a rehearing below. So there's nothing exotic about the court taking a view of the material that was before the decision maker, in this case, the tribunal, and deciding whether or not they went awry in the reasons that they did. So my submission is that if you think there's something wrong with the judgment below, and you're not convinced by my learned friend's argument that the evidence, the post-decision evidence, has reached such a stage that no other alternative decision could be reached below, then it ought to go back for a rehearing of the issue. There's a couple of points just before I get to the new evidence I just wanted to just pick up on what my learned friend made. The first is that he very squarely puts his case that the tribunal didn't make a finding of dishonesty. Quite difficult to read the judgment given the appellant's evidence on the point without essentially reading in a finding they didn't believe in. Because it's a very binary point. He either posted the claim to the Upper Tribunal on the 26th of March or he didn't. And his evidence was that he did, and he produced a certificate of posting and said he did. The only real logical inference one can take from the judgment is that they disbelieved him and they disbelieved the provenance of the document. Otherwise, it simply doesn't really make any sense. And that throws into relief the reasons that they gave. The other thing I just wanted to highlight is it's very difficult to see what possible relevance their reference to their experience of Sunday opening generally can be if they don't apply it to the individual case and extrapolate from it. And it's important to note there's no modifiers in what, or qualifiers in what the tribunal actually say about post offices opening on Sunday. They don't say, for example, in our experience, it's rare for a post office to open on Sunday, or in our experience, very few post offices open on Sunday. What they say is, in our experiences, post offices aren't open on Sunday. And that is a very general point without modification or qualification. The other thing, I suspect the court won't want to descend into this level of granular detail about the build-up to the hearing, but just because it's been raised, there was a discrepancy regarding the dates that was raised by Judge Norton Taylor. My instructing solicitor at page 204 of the electronic bundle internal pagination 180 put in a witness statement at the time explaining how those discrepancies came about and explaining that they weren't the fault of the appellant. But perhaps the neater point is
was that in response to the judge's order?
No, this
She did that before.
I'll check the date. I think that might have been in response, but I'll check. But the neater point perhaps in all of this, of course, is that the Upper Tribunal, in the decision under appeal, don't reference any of that material in terms of their own decision. So
Yes, this is an appeal against the order of the Upper Tribunal made on the renewed application for permission.
yes, and it's a complete, at that stage, it's a complete rehearing. They completely start again in terms of their view. And it's quite rare, in fact, as my lords will both know, for the original decision to be referred to in any particular depth, because it is largely irrelevant to the new judge's decision.
Yes.
But in any event, so where we've got to before I move on to the new evidence, my lord, is squarely a submission that it was judicial notice of a fact that it was impermissible to take judicial notice of. If you're against me on that, it was certainly a mistake of fact in the ELR sense. So taking into account in public law terms of an irrelevant factor, a factor that wasn't true. If you're with me at that stage, it would only be, in my submission, if you considered that the new evidence was such as to be essentially incontrovertible, that he would dismiss the appeal on materiality grounds. In the same way as the authorities on procedural unfairness essentially point to an inevitability test often in terms of what ought to happen. If you think something went wrong at the time the decision was made, it would only be really in circumstances where there was an incontrovertible piece of evidence that meant that it would be essentially futile to send it back.
Can I just clear one thing out of the way? In an ordinary judicial review case, the court is sometimes invited to dismiss an appeal under Section 31 of the Senior Courts Act. But that doesn't have any bearing on this.
No, I think it's a different test. It's a different test because, firstly, you're sitting as an appeal court against a decision of a lower court, and so you don't have that. It doesn't bite. The statute doesn't bite in any event, and you don't have the same level of in deference to the original decision maker's decision as you would necessarily in certain circumstances in judicial review.
Right.
So no,
Is this what we used to call the simplex test?
Yes.
That is it inevitable that the decision would be the same, but for the error, assuming there is an error, and we'll have to consider.
Talking in the abstract for that.
Yeah. But your submission is, as I understand it, that assuming that you're right, that the Upper Tribunal fell into error in its approach, it would only be if the outcome is known to this court to be inevitable, that it should dismiss the appeal.
Yes, and so it would have to be, yes, that's the way I formulate the legal test. And to draw it into the particular circumstances of this case, it would have to be that you consider the evidence now put forward by the Secretary of State is essentially of such a degree and level that there's no answer to it. And with all of the caveats that you're looking at it simply on paper, the lower court, if they wish, could have a hearing where the direct testimony of the appellant is set against the paper evidence, and he could be asked to be put to him in cross-examination, which has obviously never been done before. So with all of the limitations of post-decision evidence at this level would have to be taken into account, and you would still have to be able to conclude that with all of that in mind, there's no answer. There are some examples in this court of where that's happened in the immigration context. And for example, where somebody's claim is based that in May 2005 I was being tortured in a cell in Kabul. And then evidence in some cases emerged they were actually in Spain. And in those circumstances, one can see that one might be fighting an uphill battle to argue that there's any point in it going back to the court below. This is not this case. The high point, really, of the respondent's new evidence is the web scraping of what's said to be an archive by the Wayback Machine of what was said to have been on a website on the 21st of March 2023. Take the obvious point first of all, which is that this evidence is not put forward by a computer expert. We have no surrounding evidence as to the reliability of the Wayback Machine's evidence in an individual case generally. My own friend's instructing solicitor who's doing her best, and don't doubt either her bona fides or her veracity in any way, but she's not a computer expert either. And so if one discounts, as I submit one ought to, the multiple hearsay email chain, where nobody's actually giving, by the looks of things, direct evidence about what they know, you're really left with the respondent pointing to a web-scraped archive in 2023 and saying, well, there can be no answer to that. And in my position, just to frame it like that, just to say that out loud, shows that that can't possibly be the case, particularly where the appellant will give direct evidence that he was there. Also, just touch on, and my own friend described it as quid pro quo, the first application for new evidence, then met by the respondent's application for new evidence. There is a quid pro quo because we have attempted to put in yet more evidence in response to that multiple hearsay in the shape of a witness statement from Manish Patel. Now, obviously, on its face, that's important potential evidence. I accept that this is not the arena in which it ought to be ventilated and tested, but it does go to the question of whether or not there is any sensible answer, or could possibly be any sensible answer to the respondent's evidence at this stage. And I should say, obviously, that the appellant has put that witness statement in direct response both to the evidence that the respondent relies on, but also in direct response to an invitation by the respondent to obtain the witness statement from Manish Patel. So that's why it's been done. And it really goes to one issue at this stage, and one issue alone, which is whether or not the evidence put forward by the respondent is unanswerable. And the short point, for the reasons I've set out, is that it's not. I have, in a bit more depth in the supplementary skeleton, engaged with the reasons why we say the email evidence is problematic. I've taken the point that was raised earlier, that it is not only the multiple hearsay, somebody asking somebody about what they think happened in an email that's then adopted by somebody else. So there's a lot going on in that chain. And in terms of where we end up, that is, again, not capable of reaching the heights of inevitability, which is probably the highest test that the court applies. It just simply doesn't get anywhere near that. So, as I said at the outset, my submission is that this is a much simpler case than the flurry of paperwork that's actually indicated. The only question is, did one way or another the tribunal fall into error by taking something into account they ought not to have done? Was it material at the time? And then is it inevitable that they would reach a similar conclusion on the basis of the new evidence that's been put forward? And the answer to that last question is clearly not, unless I can assist.
Yes. We would like to rise at this stage to consider the next steps.
Court arise if able.
Yeah, they were very pleasant, weren't they? No. You see lies, potentially stay there. But if they, even if they did do that, contingent, would either be immediately settled.
Yeah.
Not settled.
I understand. It must be very frustrating. The problem is, well, of course, which is actually what I
Yeah, exactly. So it's a learning curve for us as well, isn't it? Well, it's it's not like it's we knew that was the case. And we'll need that in the tribunal. So
Let's just get this in as we can get before then. Latest evidence. I mean, when the submissions and everything,
yeah,
that's
I don't know.
yeah.
I don't think anything will turn up. Sorry?
Yeah, they did.
I'm afraid so.
They sent an email.
Listing basis.
I'd put my best in. Do you think we should do a joint chivvy on that?
Join what?
Chivvy.
I had my solicitor's chivvy after 3 months. When was 3 months? At the beginning of October, I told them to chivvy.
Your case as well.
No. Yeah, I told them to, because there's a sort of, isn't there a sort of unwritten rule of kind of 12 weeks as a kind of target?
I think they've got written rules now, haven't they?
I was there, so if they actually got 12 weeks as an actual target.
I don't know.
I don't know where it came into my head, but I had in my head 12 weeks as a
Yeah.
kind of
I mean, when was it? Can you remember?
beginning of July. Because I remember her saying, you know, I'm going to try and get this done by the end of July.
Yeah.
It might even have been the end of June. It was whatever. It was either right at the end of June or right at the beginning of July. Because I remember her saying, I'm going to try and get this done before I go away. And I was a bit annoyed because I was like, I'm going away on the 1st of August. If you send me a draft judgment that's 50 pages long and ask me to.
I wonder what the problem is. I suppose it's your, as we said earlier, there's not direct authority on the points. You've got to read things in from other directions.
Yeah. No, it must be that she's got other stuff going.
Yeah, the last chivvy was what? A couple of months ago.
A month ago, beginning of October, I said.
They didn't get replies.
No, she got a reply. She got a reply saying something like a grumpy reply saying she's got it. It'll be with you and you.
There's not much point in doing a chivvy. Once you've had one chivvy with that, what's the point in doing that one?
She knows we're after it.
She probably knows that someone's not
Court rise if able.
Thank you for your patience. We don't have any further questions. We will reserve judgment in the usual way, and draft judgments will be circulated on a confidential basis in the usual way. As you know, but may I emphasise, this court takes very seriously any breaches of the embargo if anything is leaked before the judgment is handed down. And the purpose of circulating the draft embargoed judgment is for factual errors and typographical errors to be corrected, not for any other purpose. We envisage that there will be no need for further hearing and that any outstanding applications can be dealt with on the papers, probably at the same time as the judgment hand down. But if the parties need further time beyond that date, then we will consider any such application. Is there anything else?
Not for me, thank you.
Not from me, Mark.
Court rise if able.
Take this horrible thing off my head. See you in the Upper Tribunal.
Maybe back in the court of appeal on that one.
I don't. Oh, that one. No, I'm talking about this when we come back around.
Yeah. Perhaps Mr. George can take it over again.
Yeah. He's not your chambers, though, is he?
No.
No.
I don't know. You're a decker, aren't you?
Yes.
What did they used to be called?
So when there was a merger of two chambers.
Yeah.
So I was one Chancery Lane.
Oh yeah.
But not. They don't do very much public law. So I'm a bit of an outlier. They do a bit these days. I feel like I'm driving the change.
Well, I'll tell you what, the other case was the Alcacia.
Yeah.
That, I mean, you never know, but that could go quite a long way up.
Could go high.
Yeah, I think so. It's a genuinely interesting point without direct origin. With arguments on both ends. Yeah.
But it's also quite a rare facts pattern, right? How often do you get a really dodgy solicitor?
Yeah. True. You can see this court being interesting.
Yeah. Thank you.